Hey, you've been talking about wiretapping for a while, and this the Shopify case or the Shopify ruling is super interesting. Can you tell us about it?
Sure. So it's not yet a ruling, but we have this issue. We've been talking about wiretapping ad nauseum, some might say. And just to maybe refresh, that is the allegation that, let's say, company A, you go to company A site, that company A is integrated in some way with a third party, whether it's ad tech here, whether it's a payment processor, and the information you give to company A is being intercepted or illegally recorded by this other party, whether it's an ad tech provider, whether it's a payment processor. So in this Shopify matter, that is the issue. We've talked a lot about California wiretapping claim SEPA. And in that case, and this is all the way up to the Ninth Circuit, private right of action was whether that's illegal wiretapping. And it's up before the Ninth Circuit. And so what the new development is you had 30 state attorneys general and DC and a number of California's city based lawyers, district attorneys, put in what's called an amicus brief to support, hey, Ninth Circuit, you should revive this class action. And it's fascinating. They're focusing on jurisdiction, which is a legal nexus argument, but nobody's talking about the comprehensive privacy laws. These are wiretapping laws about requiring consent and and permitting a private right of action. And I just think kind of given what is on the board with, if those laws continue to get support, go forward, it in some ways just really makes all of these comprehensive privacy laws on major issues irrelevant.
Why is that happening, Alysa? Is the wiretapping laws is there easier paths for them in the courts? Like, why is this happening? Yeah.
There's a clear private right of action. So that means that they get to fight this issue at the district level. You have lots of different district courts. You get to fight it at the appellate level, but we don't have really a ton of appellate decisions on these issues. And these are states. So we've got our state patchwork. It's not like at the federal level where maybe you have one agency that has power to interpret certain things that can really narrow things or broaden things. And so there's not an end in sight, which is the issue.
And the assumption that the wiretapping laws are that broad that they can capture sensitive and personal data, capture some of these, like, for example, targeted advertising use cases that privacy laws seem to be addressing.
Well, that is the concern, because what companies are facing is these either lawsuits or demand letters asking for payments or really big arbitration claims saying that, yes, your use of or your engagement with XYZ third party, you did share my information with them unlawfully. You didn't have my specific consent to do so. And their choices fight it out, as we've talked about in the past, and have a pretty hefty legal budget to do so with not certainty as to how those cases are going to evolve. That's a pretty expensive legal budget to have to take it to the end without a clear answer on your chance of success.
Gotcha. So what are the pathways now? Like, what are the how could this unfold? Do the courts come back and say, well, no, the wiretapping law wasn't meant to cover this. We have privacy laws. Like, does that happen? Does an agency do that? I mean, in light of Chevron, probably
Right.
not so much
Well,
now, right?
it's states, so we don't have one agency. And I think that's the pain point here. It's incremental. This could be 10 years. This could be 15 years, unless there really is a compromise struck. And so federal law, if there was a federal privacy law that preempted specifically these wiretaps, but that was never on the docket. Like even APRA wasn't contemplating preempting wiretapping laws. And so I just think it's ironic. We've been fighting so much about on federal legislation. Should there be a private right of action? What should it cover? Should it be what is opt-in reserved for sensitive information? It's interest-based advertising part of it, when this is happening already. It's already there is a private right of action with these wiretaps, and they are pursuing all ranges of data that's being shared in ways that I think some of us had thought was fairly innocuous and clear to the consumer.
Fascinating. Has there been any precedent for something like this, where there's been new laws starting to come online, and then, hey, here's this old one that everybody's, all of a sudden excited about, and then somebody comes in and just rationalize it? Has this ever happened? It must have.
Oh, it does in different ways. I mean, I think, but with some distinctions, right? And so the last example, which is different in an important way, but the last example that comes to mind is TCPA, the TCPA wave. That was more than a decade of a whole lot of litigation. And it was because there was this definition of what is an auto dialer. And it was so broad that using any kind of technology was considered using an auto dialer, and you needed this bells and whistles type of consent, or else it was per se not lawful to call a cell phone or to text a cell phone. So many, kind of the volume that we're seeing of these wiretap lawsuits. But finally, it's a federal law, you had the FCC interpret that, and there was litigation over it, and it went all the way to the Supreme Court. So this is a long journey to get to the point where that term was narrower than what it had been litigated over. That was a long journey to get there. And so the question is, on all of these different state wiretapping laws, which require two parties' consent, that's the hook.
Gotcha.
Where's the end? Does this get to a Supreme Court? Does this get to a state? We're not even remotely close there. And so that is the frustrating part of, like, how do you build privacy infrastructure? What are your defaults? And if you don't have that in very clear black and white, I think it's really hard to persuade a company to say, you be the first one to raise your hand and go to a consent model, right? And you don't see that happening.
Wow, it's fascinating. And you've been talking about it for a while, but it seems like it's finally here.
I think it's bubbling up, and just the fact that all these state AGs who are arguing, for these comprehensive privacy laws, they're also supporting essentially wiretapping laws. It was on a different, they were argued on a different legal issue, but it's supporting the ability to have these private right of actions, alleging privacy violations on the basis of wiretapping laws.
And is that last question, Alysa, is that an example of state AGs just using weapons available to them? And okay, we have our UDAP laws, maybe we have a state privacy law, now we have this wiretapping thing. We're going to use anything we can to protect consumers. Is that it? Or
I think it's picking and choosing, right? So they coalesced to file this statement in support of a class action being able to move forward without addressing the elephant in the room was that case is about wiretapping and a privacy violation. And these cases are happening, and there's not an acknowledgement of those. And how do you reconcile comprehensive framework that says opt out with old 1970s state wiretapping law that requires a different result?
Wow, awesome. So what's the next step here? What are we looking for?
Just a lot of litigation. I mean, it'd be interesting to see what Ninth Circuit does. So clearly that'll be one appellate. It won't resolve everything, but it'll certainly be interesting and telling.
Okay, we'll watch it. Thanks, Alysa. This is fascinating.
Never dull.
No, I know. I'll see you.